Welcome to the virtual rebroadcast of PubCA's 2024 Government Contracts Annual Review. During this week, we are presenting 14 panel discussions featuring more than 70 expert practitioners, as well as 2 in-depth conversations with key government officials. PubCA publishes news and insights for the government contracts community, such as PubCA Protests and Claims, PubCA Cybersecurity and Data Privacy, and PubCA Compliance and Enforcement. In addition to our annual review, we also host webinars, podcasts, and in-person networking meetings during the year. If you'd like to learn more about PubCA, visit us online at pubcagroup.com. All of this week's presentations were recorded live at our in-person conference in February at the Ronald Reagan International Trade Center. You can join any or all of these sessions during the week using the same link and password you used today. All attendees will be in listen-only mode. Your video will remain disabled through the entire session. Many of our panelists are joining us today to answer questions about their presentations. Enter your question into the Q&A box at the bottom of your screen, and the panel will address as many as possible during the webinar. If time allows, we'll open up a live Q&A session after the video presentation. Our briefing book, which includes all of this week's slide presentations and other materials, are available for download from the PubCA website. We are applying for continuing legal education CLE approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect acceptance within the next few weeks. We will notify all attendees when those approvals have been received. If you received CLEs for our in-person event, you can apply for additional CLEs for panels that you may have missed. And finally, if you are interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll is a simple yes/no question. We will keep track of all responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on the next few slides. Our sponsors also provided speakers for our event and other valuable input. We encourage you to review the strengths and capabilities of these firms and to reach out to them directly with any questions you may have. And now we present our next panel.
All right, good afternoon, and welcome to the last session of the day. This is the judges panel. My name is Rich Rector, and I'm a member of the government contracts team at DLA Piper here in DC. I've had the privilege of practicing government contracts law for 35 years and have represented contractors in lots of different industries, defense and aerospace and IT, and in state and local as well as federal procurement. And with me today, it's my great honor to moderate a discussion with this distinguished panel of jurists from 3 of the specialized tribunals that decide cases involving U.S. government contracts: the Court of Federal Claims, the Government Accountability Office, and the Civilian Board of Contract Appeals. We've collaborated on the substance of today's panel, and we've decided to focus on practical advice for litigating government contract disputes. What's effective? What's not? What should litigants avoid doing? And what should they do more consistently? We'll also look at some of the practical lessons that the tribunals have learned coming out of COVID-19. It was a major disruption, obviously, to the legal system, but I think some things have been learned by the boards and GAO and the court, and we'll touch on those as well. So we're expecting an interesting lively discussion. I've asked each of the members to keep their answers to about 2 minutes, so we'll try to keep moving quickly. We'll see how we do on that. You know, lawyers, we love to talk, but let's get started. I'll do a quick introduction of the panelists. To my immediate left is Judge Richard Hertling, judge at the U.S. Court of Federal Claims. Judge Hertling graduated from Brown University, received his law degree from the University of Chicago Law School. After graduating, he clerked for a year for Judge Henry Politz on the U.S. Court of Appeals for the Fifth Circuit. He then litigated constitutional and regulatory cases as a trial attorney in the Federal Programs Branch of DOJ's Civil Division. He served in senior staff and counsel positions for the Senate Judiciary Committee and the Governmental Affairs Committee, as well as for Senators Arlen Specter, Fred Thompson, Peter Fitzgerald, and Lamar Alexander. He also served in senior policy and legislative affairs positions for the Department of Justice, and he practiced for 6 years at Covington Burling in their public policy group. He was confirmed by the Senate and sworn in as a judge at the court in June of 2019. To his immediate left is Ken Patton, Managing Associate General Counsel at the U.S. Government Accountability Office. Mr. Patton graduated from Morehouse College and received his law degree from the Georgetown University Law Center. After graduating from law school, he started as a judge advocate in the U.S. Army on active duty. He then worked for the Office of General Counsel for the U.S. Department of Health and Human Services. In January of 2002, he joined GAO as a senior attorney, supporting GAO's defense capabilities and management team. In 2006, he became the Assistant General Counsel supporting GAO's contracting and national security acquisitions team. And in 2015, he became one of 2 managing associate general counsels at GAO, who are, along with Ed Goldstein. And together, they are responsible for GAO's bid protest function. They oversee GAO's bid protest process and are responsible for leading and managing the 30-plus attorneys who resolve bid protests at GAO. To Mr. Patton's immediate left is Judge Harold Lester, who was judge and vice chair at the U.S. Civilian Board of Contract Appeals. Judge Lester graduated from Furman University and received his law degree from Washington and Lee, where he was executive editor of the Law Review. After graduating from law school, he started as an associate at Seyfarth Shaw, then served as a trial attorney in the National Court Section, the Commercial Litigation Branch of DOJ's Civil Division, where he litigated contract and other cases before the U.S. Court of Federal Claims. He was then promoted to Assistant Branch Director for the National Court Section, just in time to miss the court's bid protest jurisdiction. And he served in that role for 14 years, where he oversaw both contract disputes and bid protests. And then he moved briefly back to private practice at Vedder Price for a year, and then became a member of the Civilian Board of Contract Appeals on July 14th, 2014. And in June of 2021, Judge Lester was appointed vice chair of the CBCA. So a distinguished panel, broad range of experience, private sector, government. So we think we will have a good range of perspectives and experience. Mr. Patton, I'd like to start with you. The GAO has handled roughly 2,000 protests a year over the past 5 years on average. That's a lot of litigants, a lot of experience. And so the first question is there a best practice that, or a set of best practices that you would identify for bid protests before the GAO?
Well, thank you for the question, and thank PubK Law for sponsoring this event. It's really a pleasure to be here with all of you and to hear all of the panelists provide information that, while I could have gotten it in a book, it's much more pleasurable to hear it in person and to reach out to fellow colleagues. And Rich, with regard to your question about what are some best practices that we could sort of provide to litigants, I was sort of looking through my notes and talking to fellow colleagues at GAO, and unfortunately I came across about 5 to 10 pages worth of best practices that I could probably provide to this august audience here, but I don't think they want to hear all of that. We're at the end of the day, so I'll keep it somewhat brief. But I would have to say that there are a couple of principles that I think sort of overlay what goes on here. We're all professionals. You're all professional people. You've probably heard a number of these things that I'm about to mention, and I would simply say to you that those individuals that do them best are the ones who I think are most persuasive and successful at GAO. And the first one is, and it's probably not one that you think of very often, and that is be kind and be professional and be respectful, not just to the GAO attorney, but to each other. You know, GAO is there to resolve the issue. Okay, we're not there to listen to you all fight amongst each other unless it's really digging into the issue. We want to hear the facts, we want to hear the law, and we want to hear your arguments. We don't necessarily want to hear you argue about personal attacks with each other. So I'd say be respectful. The second thing that I would tell you to do, and a lot of you do this, but I think those who do it very effectively do it subtly. And that is, while it's always key to talk about the case law, to talk about the statutes, the regulations, we expect that, that's the minimum. But those practitioners who are able to explain the theory behind why a particular rule, regulation, or case is important are those who are more persuasive or principle. So let me give you an example of what I'm talking about. Fairness, competition. One argument, one level of the argument is to simply say, the agency didn't engage in discussions they were required to, we should win on that. The deeper level talks about not only did they fail to engage in discussions, but it's unfair to me and it's unfair to the contracting officer because they're not getting the benefit of the deal. And those practitioners that go that extra mile to sort of give us the rationale and sort of raise up that principle that underlies a lot of these regulations and rules, I think are most successful in our forum. So competition and fairness are two principles that I think you should weave into your arguments when you're practicing before GAO.
That's great. Judge Lester, I asked the question this way when we were preparing. I said, what is something I said, fill in the blank. It constantly surprises me that litigants do X in our cases. So, but this is a best practice. You can turn it into a best practice as well.
Morphing it into this question.
Yeah.
So actually, though, I will respond to what you said too. I actually totally agree with your last comment there. I even as the judges, we talk about it, like we can just say in an opinion, oh, the law is blah. But I find it helpful to explain why the law is blah, because there is usually a reason for it. And people forget that. So sometimes it just becomes so rote that, we know you have to do this or that. But it is helpful, I think, especially if things are going to go up to the Federal Circuit, which is our appellate body. They don't necessarily know why the law is the way it is or has been for 4 years. And I think sometimes it's helpful for the judges to explain that. Explain, well, why do we think this fits here and how is that fair? Even if it might seem unfair in this particular case, overall, it has to be this way because then it's unfair to, we have a consistent rule of law and it applies to everyone. But anyway, but the thing I was going to mention was the thing that I was actually surprised by, and you told me when I told you about this that, oh yeah, lots of people say that, but it still was a surprise to me, and it is still a constant surprise to me how often people spend so much time and energy working on proving their entitlement cases. This was wrong, this was a change, this was a different site condition. I spend a lot of energy on that. And then you win on entitlement and we get to the damages and there's nothing there. And sometimes it seems like it should be a very simple thing, just putting in or sharing with the government time records, your daily activity reports. Sometimes it's just, we spent 50 hours working on this. Oh, okay, where's your support for that? Well, I said 50 hours. It's just, and it's like, it should not be that difficult. It feels like to me, but when you don't do it, you've wasted, I feel so bad. And as the judges, we debate it too. Like, we know that they worked on it, but there is a Federal Circuit decision, DACO, that says, well, you have to show justifiable inability not to support your costs and the time that you incurred before we can do a jury verdict. And we struggle with that because often you see that, yeah, they did spend some time, but we have no idea how much, have no idea if you really spent all that because there aren't any contemporaneous records to go with it. And it happens so often. And sometimes people even testify, oh yeah, we have these records. And you say, well, where are they? Couldn't find them. Like, well, so right. I find that frustrating.
Yeah. And from a practicing attorney's point of view, just get an expert or get a consultant and get a person like that early on to help you frame the claim. Because I've also seen cases where the claim was framed one way, and then you're kind of stuck with that. And looking back on it, maybe it would have been better to have been framed a different way. And so get that expert early and rely on it.
Well, it is. I do find like the more complex cases, like damages, construction delays, where you have an expert, where it's more difficult potentially to put your damages together. Those are usually better supported than sometimes just the simple stuff. People I think they just forget about it, or they think, oh no, we've proved entitlement, so they don't take that next step. And
Yeah.
I would just encourage people, just think about it and make sure you've put that in the record
Very
or
good.
gotten a stipulation with the government.
Very good. Judge Hertling, let's ask it this way. Do you recall a case in which you thought counsel for one of the litigants was particularly effective? And if so, what did he or she do in that case?
First, let me thank PubK for asking me to participate in this judges panel. This question is a natural follow-on to what Mr. Patton and Judge Lester just answered about best practices. You're now implementing those best practices in particular cases. We have, of course, in our court, and I'm sure that my fellow panelists do as well, very experienced practitioners, both in bid protests and typically in CDA claims. Especially if it's from the bar here in Washington. I've had several cases that were exceptionally well argued. One stands out in my mind. It was a very significant contract, money-wise. And so the parties were going to put big dollars behind it. And one side had dozens of slides that very carefully laid out the relevant provisions of the solicitation, relevant provisions of the FAR, relevant provisions of the protesters' submission proposal, and relevant provisions of, this is the intervener that I'm thinking about, relevant provisions of the awardee's proposal, and most importantly, the relevant provisions of the SSA's evaluation. And it really narrowed the focus to precisely what was at stake. And we heard Judge Lester, Mr. Patton talk about the law and the principles underlying the law. Fundamentally, in well over half my cases, those are important factors, but what's really important are the facts of the particular dispute. And in that case, this intervener did an exceptional job. You don't have to have slides if it's a small business, if the case isn't going to generate the kinds of fees, if a lawyer can't bill a small business, those kinds of fees. You don't have to put slides in front of us, but to the extent that you can tie very specifically language from the solicitation to language of the agency's decision and evaluation of the proposals, and then the specific proposal language that the sides are fighting over, that'll do the trick. And don't just throw everything against the wall. Be as specific as you can about what you're going to challenge, and then what, in this case, the other side was defending.
Okay. What about, Mr. Patton, what about an intervener? Let's just focus on bid protests quickly here. How can an intervener be most effective in a bid protest? You've got three parties. You've got the government, you've got the protester, you have an intervener. In your experience, how can an intervener be most effective at the GAO?
I think there are a couple of things that an intervener can do to be effective at GAO. The first is obviously to make sure you make those arguments that are in the interest of your client. And we have had cases where interveners were silent on issues that were discussed, and then later on, they wanted to re-raise those issues, and we held that, well, you had an opportunity in those earlier cases, you didn't take it. So now you're barred from raising that issue later. It's untimely in our forum. So what I would tell interveners is to take the opportunity to make sure you make the arguments that are in the interest of your client when you have that opportunity. And the second thing that I would say is that while the government and the intervener may seem to have similar interests, they're not actually the same. They're perhaps parallel. And they may diverge in certain instances, especially if the agency is thinking of taking corrective action and the intervener says, well, no, I think my client deserves that particular contract. So what I would tell interveners is to make sure you highlight those arguments that you think are important for the resolution of that case. Don't just rely on the government to make the argument and then say, we agree with the government. Go ahead and make your argument, add the facts, add the principles that you think are important, and 9 times out of 10, that may actually carry the day more so than the government's argument, because sometimes the intervener will raise an argument and brief it to such a degree that it becomes dispositive in that case. So I would tell interveners to go ahead, make your argument, and protect the interests of your clients.
Okay, very good. Judge Hertling, how about you? How can interveners be effective at the court in your view?
Yeah, I'm going to second most of the things that Mr. Patton said. I would say, first off, while your interests as an intervener differ somewhat from the interests of the government, it is still important, I think, for the intervener to coordinate and collaborate with the government. If you're an intervener, don't just pile on and regurgitate the same arguments the government's going to make. The government usually does an excellent job of defending its decisional process. Doesn't always win, but it usually does an excellent job of defending it. We don't need repeat player going through the same things. So precisely what Mr. Patton said, if you have, as an intervener, discrete and specific interests that you can pursue for your client, I would do that, but do it in collaboration with, in coordination with the government. A lot of times we get protests in which the protester is lobbing certain allegations at the intervener, whether it's OCI or similar sort of things. There, I think it's particularly effective and important for the intervener to address those sorts of issues in which it's not the government that is supposed to have made the mistake, or the contracting officer, or the SSA, but if there's something about the intervener that is that is challenged, I think that's an important role for the intervener. But when interveners come in and defend their practices, their role in the proposal, in the solicitation, if they're on the defensive, be very careful as an intervener about trying to throw mud at the protester. Defend your client, but don't try to turn it into the protester is worse than we are. I've consulted with several of my colleagues on that. That almost never works.
Okay, very good. Let's talk about what folks shouldn't do. And all the judges wanted to respond to this question, shockingly. Judge Lester, you want to go first? What's something that particular practice you wish litigants would avoid, or that you think is ineffective?
We probably should have talked more before we got up here, because I'm pretty much going to say what you just said. So, but it's really about briefing, but also about just dealing with people in the case. When I've gotten briefs that are really just personal attacks on the other side, on the lawyers, on the contracting officer, on the contract, just the various witnesses, and it's just attack. Discovery, attack, and everything is so personalized. And I always think, well, then what are you hiding? Because do you not have a case? I mean, is this just, it's all about attacks, and I'm not sure what you're trying to convince me of. But I as a litigator, when I was at DOJ, I found the same thing. If somebody was bombarding me with discovery and just attacking me and accusing me of stuff all the time, it was often because that's what they were doing, and they thought maybe I was doing it too, because of course they just do it all the time. So, but I do find it completely unhelpful, and it really turns me off, and I become more suspicious of that party if they're not really just addressing the merits of the case, which to me is what they ought to be doing. Sure. And laying out for me why they ought to win, and attacking the other side and calling people names doesn't do that for me at all.
Yeah. Mr. Patton?
You know, I think, again, as was mentioned earlier, I have to share the observations of my colleagues, and perhaps not talking to the mic. You know, it's something Judge Hertling said a little earlier. It's the kitchen sink, and I'm going to approach it from the opposite side. And it's not so much the kitchen sink, but if you've got a dog argument, take it off the table. Don't just leave it in. It's not helpful. It doesn't help us focus. And in my view, that's the opposite of the kitchen sink approach. You know, routinely when you have someone from the GAO talking about best practices, they tell people, don't give us the kitchen sink. Focus your arguments. We've been repeating that year after year after year after year. Well, the converse of that is, if you have given us the kitchen sink, but once you get that agency report and you see that your argument doesn't have any legs or any merit, withdraw it. Not only does it make it easier to focus and narrow on the issues that truly matter, but it increases your credibility 100% to us, because that tells us you're focused on the issues, you're looking for the right answer, and we can engage on the merits and not worry about the vitriol or worry about you're going to take us, all around and not really get to what the heart of the matter or the issue is. So I would say to people, go ahead and focus your arguments. Your clients are interested in you winning, not how many pieces of paper you can kill by filing, ad infinitum.
Can I just follow up on that just really fast, I swear. Also, I find people, if there's a hard argument, if there's a bad precedent, sometimes people just avoid it and they don't address it. And I think you have to. If you've got a problem in your case, you have to acknowledge that and try to explain it away as best you can. If there's a bad precedent, try to explain why it doesn't apply to you or even why it's wrong, but you have to address it. If you don't, you're not going to get the resolution you want, because I'm going to know about it and you're not helping me find a way out.
The decider knows. The decider knows. You're not hiding anything.
Occasionally I don't know till later, but
Judge Hertling?
Yeah, I'll keep it short because I don't want to just reiterate what you've heard. I think it's true what we heard from Judge Lester, from Mr. Patton, works in the court as well. My colleagues are always saying, if you have 18 potential arguments, don't give us 18 potential arguments. Figure out what the strongest ones are. That's what lawyers are paid to do. It's true, you're always told, well, you don't know what going to appeal to a judge, so throw in any argument. If I get a case where I'm looking and there are literally 7, 8, 9 different arguments, I don't have the opportunity really to take a deep dive into any one of them. Whereas if I have 3 or 4 focused arguments, I can take the deep dive. And sometimes I will understand the argument, and I'll find in the record points that support the argument. So keep it narrow, focus on the strongest points. And then one thing in particular that I think we find routinely in our court, particularly in the protest context, of course, are protesters who come in and they make strong arguments on the merits, why they should win the protest. And the next point is, and it goes a little bit to what Judge Lester said before about the quantum. The next point is, see, we've won on the merits, we're entitled to an injunction. No.
Right.
The burden is on the protester to demonstrate the injunction is necessary. And a lot of times, in fact, I'd say in more than 50% of my protests, even when the protester has made a very strong case on the merits, they mail in here are the injunction standards, it's the 4 factors, and we meet all 4.
Yeah.
QED, we win.
Right.
And I would encourage litigants in protests, put additional time, thought, and effort into the injunction factors.
Yeah, that's a good one. Mr. Patton, you wanted to answer this question about it. Is there something that litigants could do more consistently to make life better for the attorneys and the clerks in your firm? Is there some consistency issue?
Honestly, I do think that keeping your arguments focused is important. I think that to the extent you can move away from arguments that have no merit, it's also vitally important. Again, I also think that to the extent you can use the facts to explain the principles underlying the law, the regulation, or the cases, I think that makes your case more persuasive. One of the things that I think litigants should not do, and that they typically do, is a lot of times you're questioning an agency's evaluative judgment. My widget was better than the awardee's widget, and we should win, period. You've got to take your argument a bit further. Borrowing a piece from what Judge Hertling just said, you've got to explain deeper. How did what the contracting officer or source selection authority do violate the evaluation criteria? How did it violate the FAR? Don't just tell me you think your solution is better than the other. That's not going to win. And it's a very hard case when you're questioning the judgment of the source selection official. So you've got to explain and tie your arguments and facts to the evaluation criteria in that solicitation and or the cases. So I would encourage people, if you're going to make that argument, make it persuasive, and don't just give us the surface level, but give us the deeper analysis and tie it back to the evaluation factors.
Very good. Judge Lester, you practiced at the DOJ, and then were in a senior level position at the DOJ, and is there something now as a judge you look back on you wish that your younger self as a lawyer would have known? Like, what would you do differently having your experience from the bench now?
I actually think I figured this out at DOJ. I had a case where we had a lot of depositions, and the lawyer for the contractor loved to call the judge during the deposition. And, we've got this issue, blah, blah, blah. And I really liked that judge, but he was always on the phone, but I could always picture him, because his voice, you could picture him going, oh my gosh, what am I supposed to do? I don't know what's going on. And as a judge, I've had people call me from depositions sometimes, and I'm like, I'm not there. It's really hard in a 2-minute conversation to understand what's going on, and usually it's a much more in-depth question. So you try to wing it, but I do find it sometimes, unless it's something that you really think can be just resolved quickly, sometimes it's better to set up things in the deposition and maybe do it on paper to give the judge more insight into what's really going on in background and the ability to actually think about it rather than
Makes sense.
those phone calls.
Makes sense. Let's shift gears a little bit and talk about what your forums may have learned through the COVID-19 pandemic. It was obviously a game changer for a lot of people in a lot of different ways. But Judge Hertling, what would you say was something that the Court of Federal Claims learned through the pandemic process?
Well, I'll speak both, primarily for myself, but I think this is representative of my colleagues. We came to fully appreciate what modern technology can do. And while it may be of less interest to members of the bar who are all here in Washington, there's protest lawyers all around the country, and there are certainly CDA lawyers all around the country. And I think that we have gotten much better at deploying technology to minimize travel expenses, legal fees, by letting lawyers who are not in Washington appear virtually for all sorts of proceedings. And obviously for a year or so, we were 100% virtual. But even today, many of our proceedings remain virtual, with lawyers from out of town being permitted to appear by video, by Zoom, or whatever the platform is. And I anticipate that will continue. And I think it's a big benefit to small businesses and in particular who don't have to then foot the bill. You know, when I joined the court in 2019, and granted I had not had a litigation career, but my observation at the time was the judges either traveled for trial, rarely for oral argument, but traveled for trial, or the parties' lawyers traveled to Washington for argument. And now a large percentage of our cases is handled entirely virtually, and I would anticipate that will continue.
Yeah, very good. Mr. Patton, what about the GAOs? I know you've experimented with hybrid hearings, and you're thinking about that. What has the GAO taken out of the pandemic?
I think very similar experiences to the court. We've learned that we can handle a lot of information in a lot of different ways, leveraging technology, Zoom, Teams, actually telephone when we're really desperate. But what I do think is also important is we've also gotten an appreciation for when you can't use these virtual technologies. We actually had one or two instances where the facts and the record were so voluminous and detailed, we actually needed an in-person hearing to go through the record so the hearing officer could talk to the witnesses and sort of listen and get first impression regarding what the record showed, what the source selection official, what that contracting officer thought, and make a judgment based on the record. You know, going through engineering documents, it's kind of hard to do that in a Zoom call. You sort of need to be able to lay them out, have someone point you to what the source selection official or contracting officer thought, and work it through that way. So we have definitely gained an appreciation for the uses of technology, but I think it has also solidified instances where technology may not replace the need for an in-person presence. But as you asked earlier, we will continue to use hybrid hearings, and we will continue to push and utilize the technology because, as the judge said, it's easier, it's more efficient, it saves dollars, travel, and you know, sometimes we may not necessarily hold a hearing, we may hold a status conference where we can just kind of talk through the issues. Because from a GAO perspective, what we're interested in is getting to the right answer. And if we can do that in a conference call versus a full-blown hearing, then we're going to do that.
Sure. Judge Lester, how about you?
So I agree with Judge Hersling that we too are doing lots of Zoom hearings, both for the CDA cases and for our FEMA disaster relief cases. And it's really, I think, I was surprised how well it works. There are definitely people, though, who still want to come in. They want to do it in person. They want to see the judge. And we are working, I don't know when this will happen, but we are trying to equip our courtrooms to allow for sort of hybrid hearings where some people can be there and other people can be elsewhere, and they don't, it doesn't have to be an all or nothing proposition. I know there are some courts that are really stepping up with that technology. There is technology out there, but I think a lot of it's still developing. Some of it's really expensive, we've found. So I don't know what we will end up with, but we have tried. I mean, I have had one hybrid hearing where people didn't speak, but there were people who were watching from away while everyone else is in the courtroom. And so, but I'm hoping that at some point we'll be able to make it so it's, and it will start to feel more natural to everyone that some people are there, some people are over there, some people are right in front of you. But it does save a lot of travel costs. It saves money for especially small contractors, but big contractors too. I mean, sometimes there's not a need to travel all the way to DC just for a one-day hearing or a 2-hour argument or presentation of a witness.
Sure. I thought it was interesting when we talked about this before, Judge Hurtling, you said you weren't necessarily comfortable with having one party electronically and one party in person. And I think that with the CBCA is, you're not as worried about that issue. Well, is that fair?
I think we just want to try to give people options. I don't think it doesn't work very well yet. So, yeah. But one day, I suspect that that's going to be the way of the world one day. Yeah. As technology improves.
Sure.
And some of my colleagues have been holding hybrid hearings. I don't think anybody's been holding hybrid trials, but hybrid hearings they've been holding. I'm not comfortable myself doing that. I think that at least the perceptions of the folks who are virtual versus the more intimate interaction that you've got with somebody in a courtroom, sure, I fear gives a sense perhaps of favoritism or that the party in the courtroom is being heard better. So when I have plaintiffs who are from outside DC, I usually give them the option. Do you want to come in for an argument, or do you want to do it virtually? There are some lawyers who, even with small businesses and they're on the West Coast, still prefer the intimacy of the courtroom, and they say, no, we will come to Washington. But when they say that they would prefer to be virtual, I tell the government that government lawyer will appear virtually as well.
Okay, very good. So we've got 5 minutes, say. I know we wanted to just touch on something new or noteworthy from the different forums that you wanted to mention. Judge Lester, I'll start with you.
Sure. I think this got discussed at I don't want to talk about a different conference, but the BC Bar Association conference a couple weeks ago, but we have been working really hard on an electronic docketing system, the EDS, which we have stolen from the GAO. We took their model. They very kindly let us borrow it. Well, have it, I guess. But we've invested a lot of time and energy and money to convert it, and we're hoping, well, at PCABA, they said in February. Now I'm told, well, maybe March. But should be pretty soon. It will be very much like the GAO system in terms of creating docket sheets and being able to, as a litigant, to pull documents out of your case.
That's terrific. That's terrific.
Sure. I will say that we are in the very, very early beginning stages of actually talking about and thinking about what impact artificial intelligence is going to have on our forum. Don't know enough about it to provide any policies or guidance on it, but we're beginning the conversation. You know, are litigants using that technology? If so, how? Does that violate our protective order? Do we need to modify our protective order to take that into account? Can GAO attorneys use AI to assist them in research? Don't know. Don't have an answer for any of that. Right. All I'm suggesting is that it's a question and that we need to begin to think about it. It's here, it's coming. I know that a number of the legal search platforms offer AI-assisted research. Again, don't know much about it, but it's something that's here. And so like the Zoom and the Teams technology, we have to get comfortable with it, we have to begin to use it, and we have to make sure we have policies and practices in place to make sure that we can protect the integrity of the forum. So, again, don't have any pronouncements, but that's something that we're thinking about here at GAO.
Yeah, makes sense. Makes sense.
I was worried you were going to say you were getting rid of your EDS document system because it's crummy or something.
Yeah, we got a better system now. You can have it.
They offloaded that to the CBCA. Judge Hurley?
Briefly, so I chair the court's rules committee, and following up on Mr. Patton's comment, we too are just beginning to look at AI and whether the real world use of AI will necessitate any changes to our rules, whether it's protective orders, whether it's any other aspects of our rules. That's a conversation that is just starting. I know one of my former law clerks is here. I can assure her and everybody else, as a student of medieval and ancient history, I will not be leading that effort.
Although some of your Senate colleagues are not as modest about that.
They can't avoid that role. So that's number one. Yeah. Number two, I would be remiss if I didn't touch on a number of legal doctrines that are generating a lot of interest and conversation, both Federal Circuit decisions over the last few years, either involving Blue and Gold Fleet, Standard and Harmonia Holdings, and SECRE, or of course, Prejudice and Jurisdiction, CACI Federal, and under the CDA, Zaffer Construction and ECC International Construction. I think constructors, I think the name of the case. And obviously it's generating a lot of these cases are generating a lot of interest in terms of breaking down what has heretofore been jurisdictional barriers to getting to the merits in our forum and in other forums that are within the purview of the circuit. And I think you're likely to see under the CDA at least more decisions revolving on getting to the merits. I think in the bid protest context, I think the jury is still out. It could very well be that the only thing that happens, especially from CACI, is we take what would have been a 12B1 dismissal and just call it a 12B6 dismissal, and you get to the same place. But it's possible that there will be other effects that we haven't quite all worked out. With respect to CACI, I would encourage people to review my colleague Judge Solomson's recent decision from the beginning of this year in Superior Waste Management, calling into question whether CACI itself is good law. Obviously, we're not in the business of overturning the Federal Circuit, but he has a very interesting and thoughtful discussion on the uncertain state of the law regarding prejudice in the wake of CACI.
Very good. Well, that's something to look forward to and keep our eye on. I'd like to thank the judges and Mr. Patton for a great session here, and let's give him a round of applause.
Thank you for joining us today. And thank you to our panelists for their presentations. And again, special thanks to our sponsors whose support made this event possible.